Let's go ahead and get started. Our first presenters today are going to be Amy Piccola and Rob Dustin, and they're going to be talking about the battle over DEI and how it's become an administrative priority. So with that, we'll leave it to you, Rob and Amy.
Well, good morning, everybody. My name is Rob Dustin, partner in the Washington, D.C. office. I'm happy to be joined here today with Amy Piccola, managing partner of our Philly office that just moved today, woohoo, and also head of our DEI committee. And we are happy to welcome everybody today. Next slide. So our agenda today is pretty ambitious for the hour. We're going to cover the watershed here and really try to give you a high-level overview. Here are the issues, topics that we're going to cover and splitting this up. Welcome the Q&As. We'll answer as many as we can later. Next slide. We are starting with an extra disclaimer today. I've been practicing law in DC for 40 years. My first experience with changes in administration was in 1980 when I was working for a nonprofit in DC, advocacy firm, when Ronald Reagan was elected. Whenever there's a change in the White House, there is changes. There's changes in policy and directions and new regulations and new efforts. But there has always been a pattern to it. There has always been rules and procedures and expectations. And when I've given this speech many, many times when the White House changes, I always use the analogy that the government is like a airship, it's like a carrier that's very slow to move. You always have long-term career government workers who sort of hold things steady and sway a little bit to the left, but not always too far. What has happened in the last 9 months, there is no adjective except unprecedented, and you can't use it or not enough. The pace has been unprecedented. There have been many agency variations. There has many changes. Early in the administration, it seemed like changes were coming every 2 or 3 days, if not more quickly. In fact, that has not slowed down. It's just going on behind the scenes. It's being done not by usual notice and rulemaking, but by guidance and policy statements and executive orders. And things are in flux and they are confusing. And for reasons we're going to talk about, there are no clear answers on many of these things. And when you call us or your lawyers call us or you call your lawyers, in many cases, we are not going to have an immediate answer to your questions. And we're going to give your best recommendations based on what we know. And that can change, and it may change by litigation. And that's just where we are and where we are for the foreseeable future. So it is a rocky ride and a lot of uncertainty, and thus the added legal disclaimer. Next slide. Next slide. So where I want to start was actually, do you have any worries whatsoever? Who is left to enforce? And the actually is a good question. In many of the agencies, there are just not nearly as many regulators and enforcers and lawyers as there used to be, and that is changing. And note, by the way, the credit code on the bottom, number 1, while we are there, of 75631. For anybody who's late, we'll take care of you later. Mass layoffs at Department of Education, activities being shifted. Civil Rights Division of the Department of Justice, at least half of them, of the lawyers and investigators, are gone. Fair housing issues that apply to our colleges and universities, EEOC decrease in staff, and everybody who's left has to basically swear an loyalty oath to comply with all executive orders and interpretations, and that's where we are today. Next slide. As just one example, there's a tiny little group that traditionally deals with discrimination enforcement of part of the immigration laws that prohibits discrimination on the basis of citizenship against non-citizens. And it has been active, not large, but they do that. Now they are dealing with complaints only about U.S. citizens and only U.S. citizens who believe that they've been discriminated against. And there's just 2 employees. And that's just one tiny little example. Next slide. The other big question everybody has been asking since day one is, what is illegal DEI? I wish I could give you a definitive answer. We're going to talk about the guidance that's been received, and there's been a lot of guidance that is out there right now from the Department of Justice and other agencies are led by DOJ. As best we know, it is any practices that identify or categorize applicants by their protected categories whatsoever and activities, and anything contrary to the executive orders, including disparate impact and that there are only two genders. And you're going to be hearing today a fair amount from Amy, one of the experts in this area, on what's going on with the Department of Education in both higher ed and K-12 schools. Listen to this stuff carefully because, as we will explain, these principles are going to be applied in all kinds of other settings, are relevant to employers, so don't zone out during those. Next slide. What can we tell about the administration's priorities? They have been pretty transparent about what they're doing and telling us repeatedly. Immigration obviously is the biggest. We're not going to be focusing on that in this session today, but it is taking away resources from a lot of other areas and enforcement resources. Claims of anti-Semitism that we're going to talk about. Claims of reverse discrimination, primarily harassment of white individuals, preferences for women over men. Ending the protections for gender identity, and we believe on the horizon there may be efforts for eliminating the protections on sexual orientation. And workplace and harassment and discrimination against Christians. These have all been laid out in various places, subtly or not so subtly, as administration priorities. Next slide. The battle is not new. For those who were around and saw the executive series last year, there was a long presentation, full presentation on these issues, talking about case law and challenges going back prior to the first Trump administration, accelerated during the prior administration, led not so much by the government, but by private plaintiffs and conservative action groups against employer and other conduct that was deemed to be unlawful DEI and challenges. And we're just going to show you a couple examples from that last presentation to give a flavor of this. Next slide. So a couple different cases that we talked more about last year. Frank versus Xerox, a balanced workforce program itself, the existence of one that purports to be for a balanced workforce based upon racial or other protected classifications was enough to constitute direct evidence of discrimination against those who are not in protected classes. The Oakland Community College case dismissed, finding no evidence the college considered race and no evidence of that promotion of racial diversity equated to bias, which is the exact opposite, but those challenges have been around for a long time. And the Young case involved training where the conclusion was that the racial subject matter and ideological messages was troubling, but found that overall the employer's training did not lead to the level of harassment because it was not severe and pervasive enough, but still found problems with the training. Next slide. A lot of these are being brought as Section 1981 claims. There is a longer statute of limitations. It covers non-employees. It is extremely broad because Section 1981 includes the definition of race as it was in, 1879, which includes, Poles and Jews and Muslims and all kinds of other categories that we think of as religious that were defined separately. So 1981 gives a very broad coverage to it. You don't have to go through the EEOC. It applies to all employers because this is a federal liability, and there's individual liability for supervisors without caps. And this is why it's a favorite tool or an add-on tool in a lot of the claims we're seeing challenging the issues we're going to be talking about today. Next slide. Two more examples, just challenging training. A white male plaintiff in Eastern District, Pennsylvania, who alleged Title VII, 1981 age discrimination claims, claimed that the whole pursuit was out to get older white males. And the Arnsold case in Connecticut, same thing, a shaming session after expressing negative opinions of DEI, leading to retaliation. criticism of DEI internally that has been repressed in the name of you are discriminating and intimidating minority employees has itself been found to be retaliation. You may think there's no free speech in the workplace, but in contexts like this, when your opinions are published, are punished, and it is claimed to be because you're speaking out against DEI efforts, that's yet another claim that can be made. Next slide. And finally, AIMS. We've gone into AIMS is the one where the recent Supreme Court decision that is important as a background to all of this. This is the one that basically says reduced the burden of proof in some Title VII cases and found that background circumstances that support the suspicion that this is the unusual employer who discriminates against the majority is not part of Title VII and was never intended to be. There'd been a split in the circuits, and the Supreme Court held it couldn't be applied in Title VII, which presumably applies also into 1981 and other claims. And it eliminated a rule that said that there was a heightened evidentiary standard whenever the plaintiff or the manager was a member of the protected class and so of the majority, and so were the employees. And given that, it's going to be much easier going forward for whites and men and anybody else who is considered to be majoritarian in numbers to raise claims of reverse discrimination. Next slide. So that's the overview. But one of the things that we can't forget is why we have DEI in the first place. This whole issue, remember why you adopted DEI programs. Diversity has long been established in social science and other research as being, diversity in all its forms, in the broadest sense, encourages entrepreneurship, makes people more efficient, makes people more collaborative, makes for better and healthier companies overall. Equity, just use the word fairness. Think about that middle term as fairness. Fairness for all, ensuring that all employees, regardless of who or where they come or their opinions or their beliefs, are treated the same, which is just sound business advice. And inclusion, making all employees, no matter what their background or experiences or any protected characteristics, feel welcomed, have meaningful opportunities. All of these things were designed to encourage and enhance non-discrimination. Non-discrimination because of historic discrimination in many companies and by many individuals. That was the purpose. And it has always been illegal to prefer somebody just because of a protected characteristic, race, national origin, anything else. That's always been unlawful under Title VII in Section 1981. That was not the purpose. So these programs that many of you developed had well-meaning and legitimate non-discriminatory reasons for them, which is why prior administrations held that a DEI program alone and these efforts did not discriminate, including other aspects that we talked about today. And that's now what is at issue. So, Amy, over to you to add anything else and then talk about who's most affected.
Thanks so much, Rob. And that was, I think, really helpful framing not only globally in terms of what we're going to cover today and sort of those foundational principles, but reminders that particularly for our presentation here, thinking about why DEI programming or whatever the nomenclature that your particular business used around that type of programming, those resources, why it was important. We'll sort of circle back or tie back into those concepts when we talk about how we can assess risk in this moment by also keeping in mind our values, those core beliefs, our priorities internally for our employees. So we'll certainly cover that. In the meantime, we thought it would be helpful to frame our discussion around the industries or industry sectors that have been notably impacted by the shift in federal administration priorities. The intention here is one, as Rob teed up for us, living in a time of uncertainty or in a gray area. We are left with not the clear-cut guardrails and rules that we are used to, particularly for those of you who are lawyers among us, but instead are learning by reference. And some of that learning by reference is looking at enforcement and investigative actions that the government has taken and seeing how they may translate into our particular spaces. So the goal here in this discussion is really to give you some things to think about to understand where you might sit in the current framework. Next slide, please. So as Rob introduced, I am a higher education attorney, so I can't help but start with institutions of higher education when we talk about those enterprises that have been particularly impacted over the past nearly or just almost to the day 10 months of federal action. Even if you are not a higher education attorney, and even if you are not sitting at an institution of higher education, it has certainly been front page news that many of the executive orders, the other administrative agency action, and much of the sort of broadly speaking headline making federal enforcement action has been targeted at institutions of higher education. And I think when we're thinking about what we can learn, what is particularly instructive here is what we have in the second bullet point. And that's the leverage that the federal government has to take these actions. So in the higher ed context, many, if not most, institutions of higher education are recipients of federal financial assistance. And in accepting federal monies, those institutions grant the federal government enforcement authority under spending clause statutes, in addition to other sort of contractual agreements. So our spending clause statutes, just to sort of root in the law here, are statutes that allow Congress to attach conditions to federal funds. So in this moment, as a higher ed lawyer, we are certainly thinking about Title VI, which is the federal statute under the Civil Rights Act that tells us that if you accept federal financial assistance as an institution, you cannot discriminate on the basis of race, color, or national origin. Likewise, historically, at least over the past 2 decades, Title IX has been front and center for institutions of higher education, another one of those spending clause statutes that said in exchange for accepting federal dollars, you agree to not discriminate on the basis of sex. Now, in addition to the spending clause statutes, we do have those, as I mentioned, sort of contractual relationships between institutions and the federal government. And many of our institutions of higher education are also federal contractors and or grant recipients. And so we'll talk a little bit about that in a second. So as I said, thinking about the leverage, those points that the government can leverage vis-a-vis our institution is really important because those are the access points. Thinking about this enforcement, this investigation, this legal landscape, and what our relationship is to the federal government in this moment. So if you are a company that directly or indirectly, and we'll talk a little bit more about indirectly, but for this moment, think about receiving federal monies through state programming, sort of the relationship and the ecosystem where even if the intention was not to be a federal contractor, monies are flowing into your enterprise from the federal government. You or your industry more broadly could be equally susceptible to this leverage point, just as institutions of higher education are. Next slide, please. So if you are a federal contractor or a grant recipient, you have likely already received certification or attestation requests in language that will track the language of the various executive orders that we will talk about in just a few minutes. So these requests for certification or attestations, one, conceptually are not new, right? This has always been part of the federal contracting and grant making scheme. But the certifications now are very specific and they sort of flip on their head some of the certifications, certainly in the higher ed space we had been making before. The types of things that we see here are certifications that your entity doesn't engage in illegal DEI to attest to things like you don't inculcate gender ideology in your program. And it's really important here when I'm thinking about these certifications to remember that they are broad. They speak in terms of your entire enterprise, your entire institutions, not just in terms of a direct grant recipient. So to use a higher ed example, if you have a research grant, the certification that will come part and parcel with that research grant will request that a certification be made that your institution, not just the researcher, the principal investigator, and the particular lab, don't discriminate, don't engage in illegal DEI. Put a bracket here just to note that we recognize that past administrations, including right up through January of this year before the change in presidential administrations, actually required DEI grant provisions around staffing, the numbers of people that needed to work on particular types of grants, the efforts we would undertake in employment, in sourcing materials, and the like. And the current administration has been working to sort of ferret those out and eliminate or amend them. So we'll have an opportunity to talk more about this concept in the what do we do with all of this information a bit later. But one of the things that we really have to consider when we're talking about these broad certifications, sort of headline, we as a corporation, as a business, as an institution, as an enterprise, do not engage in illegal DEI. How can we make that broad certification? Do we truly know what every division, department, office, and employee is doing, the programs that they're managing, the tactics that they're using for recruiting and hiring decisions, for promotions? Do we have a good sense of our employee resource groups? All of these nooks and crannies of our enterprise are subject to these certifications. So what is the work that we need to do to get comfortable, which we will talk about. But for the moment, if we can move on to the next slide, and Rob, maybe you can
Amy,
talk to us.
let me just add one practical thing that you didn't mention, which is often your human resources department or your general counsel's office does not even know all of the federal government grants or contracts that they may have. I have often seen situations where the patent office or this section or that section is getting money from directly or indirectly where those paperwork went straight out back to the government with no review of that procurement or its terms and conditions. And that is a huge loophole for you because somebody then has signed off that you're not doing anything without any legal review.
Yeah, absolutely. When we talk about those nooks and crannies, that's exactly what we're talking about. And in fairness to our line employees, there was no expectation. It was the autonomy to run your particular division, to manage your contracts, that historically has been more efficient. And now, how do we get our arms around those things? I think we'll talk a little bit more about that towards the end of the presentation. But it's a good thing to keep in mind as we work through these dynamics. But Rob, while you're here, can you talk to us a little bit about Title VII?
Sure. Everybody in the room that came for an employment law seminar, you're probably covered here because you're covered by Title VII. You've got 15 more employees within 20 more work weeks in the last 2 years. And the key thing, we'll be talking a little bit more about this later on, guidance. You have not seen much activity from the EEOC. And the reason there has not been a lot of activity is that until 10 days ago, there was no quorum at the EEOC, so nobody could you had interims and interim officials doing some actions consistent with the executive orders. And there have already been changes we'll talk about later in enforcement strategies. But I think you're going to see in the coming weeks and months a much faster rate of guidance documents and revision of guidance documents and from the EEOC. And then we'll get into, a little later in the presentation, the big issue of how do you grapple with the differences between what the government is now saying is illegal and what state and local legislation, laws, and rules, and even existing federal regulations say absolutely is lawful and required.
Thanks, Rob. Next slide, please. So let's shift from talking very high level into getting into some of the nuts and bolts of the landscape that we are dealing with. And while this is certainly well-trod territory, we've had a lot of time to sit with many, if not most, of the executive orders that we're going to be talking about today. We do think it's important to walk through them as we think about how we can continue to build out compliance programs, thinking about how we can do risk analyses on an ongoing basis. So if we can move on to the next slide, it's always helpful to remind ourselves of what executive orders are and what they are not. So by way of quick reminder, executive orders are directives from the president that are not law, but that do have the force of law. So they are not statutes, they are not regulation, they do not require approval from Congress. But they are used to manage the operations of the federal government. And importantly, in terms of force of law, they issue instructions to our executive branch agencies, and we'll see a lot about that when we look at each of the executive orders. So in this way, when we think about what executive orders are, what impact they have, what they're intended to do, it's important to remember that they guide the future actions of our agencies, so our federal government. And that's where, for most of us, these directives really come to bear. It's by looking at the executive orders, where are agencies told to focus their priorities? What are the sort of issue statements or mission statements that the president is issuing that will guide those agency actions so that we start to see either enforcement action at our institutions, or we see some of these guidance documents and the like that we'll talk a little bit about as well. Next slide, please. So as previewed in talking about executive orders and what they are, there was a bullet point on the last slide that said, or introduced the topic of, sort of this authority of executive orders allows the president to not only issue executive orders, but to also revoke or rescind previously issued executive orders. And as over time, executive orders have become a real mechanism for the president to set priorities and guide the federal government, issuing the rulemaking process, relying on Congress to set these priorities for the government. We have seen a real pattern of a new administration comes in with executive orders at the ready. So we see a big push over the first few weeks of a new administration with new executive orders. And in that same push, we also see revocation of either the prior administration's executive orders, or as in the case of Executive Order 11246, the revocation of an executive order that had been in effect since 1965. So the revocation of Executive Order 11246 saw the end of affirmative action programs for federal contractors, noting, of course, that this was specific to race and gender, which will be thematic, I think, as we look at other executive orders and other federal action. Affirmative action programs and plans relative to veteran status and disability status do still remain in force. Next slide, please. So moving on to not what was revoked, but what was issued, Executive Order 14173, which is our Ending Illegal Discrimination Executive Order, gave us those certifications, or amended, changed our relationship to those certifications that we mentioned earlier this morning. So specifically, the Ending Illegal Discrimination EO requires that every federal contract and grant award include a term that requires counterparties and recipients of grants, so us, right, certify that we do not operate any programs promoting DEI that violate any federal anti-discrimination laws. So think about that for a moment. If you had caucused this group joining us today on this webinar a year ago, I think many of us would have felt really comfortable in saying that we don't run DEI programs that violate federal anti-discrimination law. We had a good sense of this is what the law says, this is how the law has been interpreted. We know the rules of the road, we know those guardrails, as Rob introduced them for us early in the program. What the executive orders don't do is provide a lot of meat that directly meat on the bone that we can sort of pick through to understand when the government thinks that a DEI program is violating federal anti-discrimination law. And so you do have to look at the whole suite of executive orders together and look at the agency action that has resulted. So certainly more on that. Also important here, and this will be a bit of a teaser for your next session, this executive order says that this certification that is now mandatory in all of our federal contracts and grants, that certification is a material term to the award of a grant or a granting of a federal contract for purposes of the False Claims Act. So as I just mentioned, you will hear more about the False Claims Act in your next session. So for immediate purposes, just know that the False Claims Act imposes liability on individuals or companies that defraud the federal government by making materially false or fraudulent statements to influence the government to enter into that contract to make payment. So this executive order directs or interprets the False Claims Act and applies that, layers that onto the certification. For those of you who are federal contractors, the fact that a certification in a federal contract or grant is a material term is not going to sound particularly shocking to you, but this was one of those breadcrumbs that the government was leaving for us that we're going to be particularly focused on rooting out illegal DEI, right? Making sure that it was crystal clear that this now mandatory certification or attestation, depending, is a material term. Of course, and you'll hear more about this as well, it's important to remember that under the False Claims Act, not only are we talking about potential claims from the government, but also from those individuals either inside or outside of our organization in the form of qui tam suits. So we're thinking about our employees, our former employees, those private citizens who are activists, whistleblowers. Thinking about that broadly helps remind us of, frankly, the scope of potential liability in this area. When we wrap our session today, or in the last segment of our session, we'll talk about internal audits, thinking about the things that Rob and I introduced here, those nooks and crannies, figure out what everybody's doing, the programs they're running, what certifications have been made that sort of escaped our notice early in the year, for example. And I just like to plant a seed for you here now that we've teed up the potential liability or ramifications of making one of these certifications. And it's a practical thing for you to consider. And that's for you and your legal team to assess how you're going to run an audit or compliance check around the particular terminology in the executive orders to assess how we sort of stack up against agency guidance. And whether you're going to do that under attorney-client privilege, which makes good sense, right? We don't know what we're going to find. We're going to likely need legal advice around remediation. But what are you going to do when you need to make that certification, or worse, if the government comes knocking with potential FCA concerns and says, show your work? Will you ultimately, in order to make these certifications, create complementary non-privileged work product to substantiate your compliance? Will you be in a position to consider waiving attorney-client privilege over any of these audit or compliance checks that you do under privilege? Just a little food for thought, and we'll again talk more about the audit process as we move on here, or the potential audit process. But I did want to just plant that seed before we move on, which we can do now with the next slide. So the Restoring Biological Truth to the Federal Government Executive Order directs federal agencies and federal employees to interpret sex solely as an immutable binary biological classification determined at conception or birth. So this is male, female, man, woman. There's no scale of gender identity. In fact, the very concept of gender identity is sort of written out of the government's vernacular in this executive order. The order does require all federal agencies to enforce sex-based rights. So whether under Title VII or Title IX in my universe, consistent with this definition of sex. This applies to the protections and accommodations that may be granted. This executive order, while it is does what it's intended to do in directing federal agencies and employees. And there's a lot in there about federal forms, documents that the federal government uses, changing to make sure that there is only a binary choice when, for example, you need to check a box of your sex to get TSA clearance or something of the sort. The executive order also has a nice, to use the term broadly, definitions section. And I say nice because it's one of the rare places where we actually get definitions in these executive orders that tell us exactly how the government is thinking about these concepts. The executive order doesn't apply to us directly as private employers unless we are a federal agency or a federal employee. We don't have to use these definitions. But I would suggest to you becoming familiar with these definitions is certainly important if you are a federal contractor or a grant recipient and you are being asked to sign a certification that says, which again we have seen, you do not inculcate gender identity or gender ideology concepts among your employees or your research subjects. But knowing these definitions will help you as you think about the other concepts baked into this executive order, which directs the Attorney General, the Secretary of Labor, the chair of the EEOC to prioritize investigations and litigation to enforce the rights and freedoms identified in the executive order. So thinking about how our government has been told to prioritize implementing and enforcing these definitions is a real clear guidance for me, at least, to know that I should be really familiar with the way the government is thinking about these concepts. Now, Rob is going to talk a bit in a bit about the conflict between federal and state law in a lot of these areas. So I would just drop a pin here to note that for many of you, there may be a conflict between the EEOC's now stated priority to create single sex spaces at work. So think restroom facilities, and state requirements around access when we're thinking about transgender individuals, non-binary individuals, etc. So again, just dropping a pin here as you navigate the sticky situation of what your local or state government is telling you is the law and what you have to do, and what our federal government has said it will do in terms of enforcement and prioritizing that enforcement.
But Amy, while we're here, I'll
Yeah.
just add, you can expect the EEOC. EEOC has already stopped all enforcement of all gender identity cases. They have tried to get out of ones that they filed before. They are not taking new ones. And you can anticipate that fairly soon they will revise all of the definitions under Title VII and all prior interpretations under Title VII that include gender identity. Now, how this conflicts with Supreme Court decisions and precedent is a whole different issue we'll talk about later.
Right. Yeah. Thanks, Rob. And, we've been sort of waiting with bated breath for the EEOC to get quorum. And I think you are wise to anticipate sort of the action, knowing what we've already seen over the first several months of the administration. And just as a footnote, maybe sort of a tangential relationship to all of this, is that this summer, the Supreme Court did decide a case, United States v. Skermetti, that it said that a Tennessee law banning gender-affirming medical care for minors didn't violate the Equal Protection Clause of the 14th Amendment. Not particularly relevant for present purposes, but did want to highlight that what the court did not do in that case is decide one way or another about whether transgender individuals are a protected class under the 14th Amendment. So that remains an open question. And again, as Rob just teased, some talk about these conflicts is coming up. We can move to the next slide, please. So the Restoring Equal Opportunity and Meritocracy Executive Order, or as it is often lovingly known, the Disparate Impact Executive Order. So for those of you who could use the refresher, just a reminder that disparate impact discrimination is discrimination that occurs when a seemingly or otherwise neutral policy or practice unduly disadvantages individuals based on their protected class. Disparate impact discrimination, you can see here and on the next couple of slides, has been codified, just since we're talking for most of you, Title VII in 1991. Congress explicitly codified the concept into Title VII with the Civil Rights Act of 1991. So disparate impact is the law, and it is the law also in many states and local jurisdictions that disparate impact theory of discrimination is viable. So keep that in mind. What this executive order does, it sets into motion steps to eliminate disparate impact liability for employers, at least at the federal level. Its stated purpose is to treat all citizens equally under the law and to combat disparate impact liability, which is perceived as running counter to concepts of meritocracy, sort of color blindness, which is a term that's actually used right in the executive order itself. The executive order also revokes certain approvals of Title VI regulations and directs all agencies to deprioritize enforcement of statutes and regulations to the extent they include disparate impact liability. So deprioritize, for example, a disparate impact theory of liability under Title VII. It also, and talk about setting things in motion, it mandates that the Attorney General and other agency heads think about and strategize around repealing or amending regulations, guidance, rules, orders that would otherwise impose disparate impact liability, similar requirements that run contra to the concept of meritocracy in the government's perspective, and asks them, and this is, I think, very much related to what Rob featured at the end of our discussion of the last slide, is to take a step back and assess all pending investigations, all civil suits, all positions in investigations and civil suits that rely on disparate impact liability, and take appropriate action to step back. So when we talk about abandoning claims around discrimination on the basis of gender identity, so too for disparate impact liability by the executive order's force. There is an expectation that the Attorney General and the chair of the EEOC will continue to issue guidance or technical assistance to employers on not just this issue, but on specifically promoting equal access to employment regardless of college education. So that is baked into this same executive order. It's one of those executive orders that's worth a refresh or read in the event that you haven't taken a look back at it since it was issued earlier this year. If we can move on to the next slide, please. Really just the bottom line here is that it's very unlikely, given all of the aforementioned, that the current EEOC is going to investigate or make findings of disparate impact. But unless and until Congress amends Title VII to repeal the provisions of disparate impact, it does remain an actionable form of discrimination. In other words, your employees can still sue under a disparate impact theory. And as mentioned, that will remain true, presumably, even if Title VII is amended, when we look at state and local law that have imported this same concept over time as well. So here we're thinking about things like whether you should continue to do adverse impact analyses, looking at your hiring, your pay, your promotion, if you are doing them under privilege, maybe for the first time, and how you are balancing, sort of the government's directive that this is an unfair analysis. It is a discriminatory analysis. We as a federal government are backing off of it, balancing that against the reality that it does remain that viable source of claims. So if we move on to the next slide, just really quick, we won't spend a lot of time here. We do want to acknowledge that many of these executive orders have been subject to challenge in the courts. But even those executive orders whose enforcement has been stayed in whole or in part, remain instructive for potential future active action, enforcement priorities, and the like. So if we move on, and you can actually move on once again, really quickly just want to highlight that we've already seen over the course of the year that our federal agencies are taking the concepts of these executive orders and issuing guidance. The Department of Education early in the year, focusing on Title VI, gave us a whole lot of information about what it felt is discriminatory and thus illegal. And even if you are not a higher education institution, I think you can look at these examples and see direct parallels into what the EEOC has advised for its part around discriminatory employment practices. So thinking about segregating our employees, or here our students, on the basis of their identity for training and educational opportunities, using racially charged or stereotypical language like white privilege, for example, in our training, having mandatory DEI training that uses this type of vernacular. These are all things that the Department of Education highlighted. The Department of Education's Dear Colleague letter, which is mentioned here, enforcement was stayed through court action. But again, it's sort of it doesn't matter because we have seen enforcement action, again, some of those headline making enforcement actions, taking these concepts. Investigations have been opened across the country, looking into higher ed institutions' engagement with third-party programs that the government has viewed as discriminatory on the basis of race, the use of training, internal training programs likewise. So again, you can sort of see the parallels. And if we move on to the next slide, you can see DOJ reading from the same playbook in its explanations of what the DOJ will view as its priorities in the same regard. So False Claims Act, subject of your next session, so please do stick around to get into the weeds here. The thing to highlight is that the DOJ, in talking about its False Claims Act enforcement priorities, says that it intends to target those entities that have received federal funds, again, because we're talking about the FCA, that have allegedly implemented DEI practices or who have knowingly engaged in racist preference mandate policies and activities that assign benefits or burdens. And remember those words, benefits or burdens, because when we're doing our internal assessments, we want to think about those concepts on the basis of race, ethnicity, or national origin. So if we move to the next slide, you can see some more examples of what the DOJ has specifically called out in the last couple of bullet points: preferential hiring and promotion practices, use of unlawful proxies, things like cultural competency as part of recruitment or promotion. These are concepts that, in slightly different words, the Department of Ed is telling us are illegal or inconsistent with our obligations under federal discrimination law under their purview, right? And if we move on to the next slide, you can see more of this as well. Picking up on all of the themes we talked about from the executive order: access to restrooms, facilities, changing areas based on a biological binary around sex, having race-based diverse slate policies in hiring, using things like underrepresentation to guide our hiring and promotion, and again, using DEI training with our employees or internally, just like at higher education institutions with our students that use those stereotyping language, or that stereotyping language like toxic masculinity and white privilege that could, in the government's view, create a hostile environment. So if we move on to the next slide here, Rob, over to you to tell us about what the rest of the government is doing.
Yeah. Well, actually, I'm going to jump in here and answer a couple of questions that all come down to what court cases have decided what is illegal DEI? And the answer is none. Absolutely none have really done this. This is illegal DEI is a terminology used in the executive orders and in guidance documents to encompass whatever it is that they are thinking are practices, policies, procedures, determinations that are contrary to the executive orders. And in order to tee up the case that you're looking for, some employer has to had some action by the federal government to sue them, or a private employee, and you defend that your conduct was legal under current law, and it eventually works its way up to the Supreme Court. And as soon as you win your first level, the government's going to be jumping on in as an amicus for the person who's suing you to say that this is in fact illegal. Or the EEOC gets its act together soon, and it starts taking on these cases and is litigating, and that goes on up. And we are not going to get some firm decisions out of the appellate court for at least a year or a year and a half. And that's what it's going to take. So we are looking, as we'll talk about at the end, at risk tolerance of government actions against you based upon things that this government thinks is illegal and have been legal in the past. But moving on to the guidance quickly, aware of our time here. A couple different things just to show you the scope of everything that has come out, that I think anything that you see one place is likely to show up other places. Let's be clear about that. DOJ is guiding all of these guidances across all agencies. So you have a guidance memo out of OPM, the Office of Personnel Management, for its own employees, saying, for example, that any effort to have diversity in your hiring panels or your promotion panels or any composition of candidate pools, diverse slates, those are all illegal now in the federal government for federal government agencies, and therefore, by implication, the EEOC is likely going to take the same position for private companies. Next slide. Another one, DEI-related discrimination at work. You should look at this guidance for all kinds of specific examples, again, directed for federal government employees about all the different things that they consider to be illegal DEI training or ways that DEI can create a hostile work environment. Expect that this will become part of Title VII guidance by the EEOC. And as just one example, even if you have separate groups that receive the same programming or content, if you separate groups by protected classifications for just about anything, that would be illegal in the federal government and presumably for private employers. Next slide. As one example of how the administration has been changing things, I do a lot of work in the apprenticeship space, which had disparate impact rules and affirmative action and non-discrimination and a very extensive set of requirements run by the DOL. And rather than trying to amend those to remove that, the proposal on the table is basically to get rid of all regulations because it's easier. And frankly, I think it's in part because there's not enough people left to be able to write new regulations that scrub everything. So much of the existing regulations have affirmative action at their core. Next slide. Two sets of memos on religious expression that are particularly interesting, even again targeted to federal government workplaces. Each of these are consistent with the Supreme Court's efforts to protect religious freedom in all kinds of contexts. Again, we're talking about federal workplaces where you have First Amendment protections, as do most of our private public sector employers out there. But a wide range of accommodations made for religious expression. Remember, Goff to Joy dropped the burden down to the same, placed an incredibly high burden on denying requests for accommodations. And the broader one is the protecting religious expression, where it talks about the wide range of activities you can express at work, up to and including participating in prayer services with your colleagues, public servants participating with tour groups in those expressions, inviting people to your church, proselytizing at work until somebody says no, all extremely broad activities that the government thinks would be appropriate in government agencies and therefore probably also in private workplaces. Next slide. Amy?
Thanks, Rob. Can we actually skip to slide 42? Thank you. I just want to make sure that everybody saw our credit code here as we close in, and Rob, give you a chance to talk a little bit about conflicts, because that has been a popular question in our chat, and I want to make sure to have time here to get you to talk about that.
So skip back to slide 38, and that's what we'll go through. No, not anti-Semitism. Conflicts with existing laws. Next slide. It's two more down. Okay, next slide. All right, so we already talked about this extensively. EEOC may not bring those claims, but disparate impact is part of Title VII. It's a theory of discrimination. It comes up a lot in selection device issues and challenges to selection. Is your current algorithm discriminating unintentionally on the basis of race, sex, national origin, or anybody else because it's preferring whites over blacks or vice versa? And you're still going to get these claims by state and local governments. It's still valid theories. You're going to get them by private employers, private employees suing, plaintiffs suing over disparate impact. One of the ironies here is that no matter how you feel about all of this, when you get some of these lawsuits, your lawyers may be telling you the best defense that you have is to say the federal government is right. There is no more disparate impact, and therefore we want this claim to be dismissed. And in most cases, you are just going to suck up and say, do whatever you can to get rid of the case for cheap. Next slide. Affirmative action. A lot of the stuff that is being targeted right now are all things that was legal under existing law and legal for good reasons. Long history that expanding the pool of qualified applicants to ensure a diverse pool, outreach to underrepresented groups, mentoring, programs, all of these long laundry lists of efforts were all considered legal by the EEOC, by the Supreme Court. They were not discriminating in actual selection. And it was always at the bottom line. You could make the pool as broad as you want, but you couldn't cross that line and pick applicants based upon those protected characteristics. And that was the line in the past. All of those are now being scrutinized and questioned and claimed to be illegal by one agency or another. Next slide. And then we get the supremacy clause. The poster child for this is the administration's fights with California over transgender participation in sports, K-12 sports, and transgender bathrooms. And the federal government is claiming that any state law interpretation that is contrary to executive orders and its interpretations, meaning that there's more than two genders, are in fact discriminatory, claiming that the federal supremacy clause supersedes all of that and states cannot have any laws that conflict with its new interpretations of federal laws. And that whole issue of how far, and traditionally, states have been allowed to have discrimination laws that went further and protected more classifications and characteristics than the federal government did. And this one will eventually make its way up to the Supreme Court in some context somewhere. But that's where this battle is being fought over is, how far can the federal government go to supersede the rights of the states? Next slide.
Thanks so much, Rob. So we have just a couple of minutes here. If you could move to the next slide, please. We wanted to sort of tie a bow on this immense amount of information to talk about, like, what do we do with all of this? And for my perspective, and as Rob mentioned, I am, in addition to being a higher education attorney, I'm the chair of our DEI committee. So I've had the perspective of both giving legal advice to my clients on these issues and implementation, but also seeing how this plays out on the ground and engaging around some of these issues. So from my perspective, at least, journeying through this moment requires us to self-reflect and identify or remind ourselves of our company's mission and values. What are the things we emphasize, prioritize, won't give up, won't do, etc. Understand our risk tolerance. Not all industries are created equal. Are you in a heavily regulated space? Do you sit in an industry that has already been the focus of enforcement that we can anticipate a continuation of same? Are you a federal contractor or recipient of federal dollars? Are you a private or a public company, recognizing that there will be different considerations there? So really understanding who we are, what we value. Also understanding, and there was a great question about this in the chat, that there's the law, the statute, the regulations, the precedential court decisions, and then there's investigation and enforcement risk that in some ways is guided less by our understanding of the law and more guided by these executive orders, the philosophies and the values of the current administration. And those two things aren't always aligned, right? Those priorities and our understanding of the law. Putting all of this into a bucket to conduct a risk analysis, developing guiding principles that take into account the law and overlay that risk analysis, and doing those audits that we've talked about. And I think from my perspective, at least for efficiency's sake, rather than playing an endless game of whack-a-mole, considering and depending on the size of your organization, you may want to do one of these comprehensive audits, which, as somebody suggested in their chat, may be a perfect opportunity to engage with your favorite Saul Ewing attorney around what that looks like and what the rules of the road are. So I see Steve is on. Steve, thank you so much for inviting me into this employment law space. And thanks, as always, Rob, for your partnership.
Thank you, Amy. It's been a pleasure.
Yeah, we were sure happy to have you join us. Thank you to both Amy and to Rob for talking about this important and timely topic.